Saygıdeğer hocalarımız ve kıymetli katılımcılar, 4. Fikri Mülkiyet Hukukunda Güncel Gelişmeler Uluslararası Sempozyumu'nun Gelibolu Konferans Salonundaki ikinci oturumu Texas A&M Üniversitesi'nden saygıdeğer hocamız Profesör Doktor Irene Kalboğlu başkanlığını yürütecektir. Duayen isim Profesör Doktor Irene Kalboğlu, Texas A&M Üniversitesi Hukuk Fakültesi'ne görev yapmaktadır. Kalboğlu, akademik kariyeri boyunca Stanford Üniversitesi,
I think we can cut down on that because just let's introduce the speaker. Let's get going so they have time to present. The bios not needed.
Bu oturumda Cezayir Üniversitesi'nden Profesör Doktor Necibe Bukumezya ve Kırgızistan Ulusal Üniversitesi'nden Doçent Doktor Saltanat Murat Bekovna olacak.
No, we need to start with there. We were supposed to start with Namibia. It's fine. Let's okay. So we start with the first speaker, who is Professor Saltanat Muratbekovna from Kyrgyzstan National University. And she's going to... Would you mind to close the door? Somebody, please. Thank you. So Professor Saltanat is going to talk. Wait. He's going to talk about copyright and specifically a research focus on the concept of literary works and some of the legal tension and problems related to it. Please, Professor Saltanat, the microphone is yours. Are you speaking in English or in Turkish?
No.
You should.
Presentation.
You speak English. You should. You should. Hi. No, she's not speaking in English.
Bana yetkinin verilmesini bekliyorum şu an.
Ne oldu dedi? Нет, на английском. Да, на английском. Нет, помолчи.
But the slides don't seem in English to me.
Hocam
I have so many comments for you.
sen de
It was beautiful presentation, super interesting. But I didn't want to show some questions. Okay, guys, okay, sure. Excellent.
Нет, на английском у меня есть. Какой?
You need to give her the flag. Да, я вступаю на английский.
Да? Дегерлик катилимчилар Балыкесер университетine ректор доктор профессор Güncel Ogulu Murtaga ve organizasyon komitesinde bu nazik davetleri için çok teşekkür ederim. Legal problems of definition of the concept and features literary works in copyrighted. Legislation in the region of copyrighted, the current legislation of the Kyrgyz Republic uses generalized concepts that encompass all types of works of science, literature, and art without distinction between them. This legislation formulation demonstrates the acceptability of legal regulation of releases arising in connection with these objects. However, the need to separate these concepts by type remains controversial. Legislation in the region of copyrighted. The Civil Code of the Kyrgyz Republic does establish any distinctive characteristics that would allow for the classification of works by type. Law of the Kyrgyz Republic number 6 of January 14, 1998 on copyright and related rights also does establish general requirements for a work to be subject to copyright, namely the creative nature of the work and its objective expression. What does copyright cover in literary works? Before talking about protection, we need to clearly understand what exactly we are protection. What exactly does copyright for literary works cover? In other words, what works considered literary and the law? Is there a difference between a novel, a media post, and a translation protected only original text? Writing works of different genres. Copyright in literary works is first and foremost the protection of writing works. The law equally protects all writing works, regardless of their genre, length, or artistic merit. What's important is that they be an original, creative product of their author. Literary works include fiction, novels, stories, short stories, novellas, plays, poems, verses, ballads, etc., scientific literature, monographs, articles, dissertations, textbooks, manuals, lectures, etc., publicism, articles, essays, reports, interviews, feuilletons, etc. Technical literature, extractions, reference books, descriptions of inventions, etc. Computer programs, yes, they are also considered literary works from a copyrighted perspective. Databases, if they are a result of creative work in collecting and organizing data, the main criteria are the rich format expression and the creative nature of the work. The work is subject to copyright protection. Exclusive rights of the author of literary work. White rights exactly does as author have. What does it mean to me being an author from a legal perspective? What opportunities and privileges does this status provide? Inclusive rights of the author of a literary work. Copyrighted grants the author of a literary work a number of exclusive rights that allow them to control the use of their work and receive compensation for their work. These rights can be divided into main groups: property and non-property. Right of reproduction. Still, book publishing is a classic example of reproduction. Copying, photocopying book pages, scanning an article, or recording a work onto an electronic medium, for example, a flash drive or hard drive, are all also reproductions. Right into computer memory, saving a literary work on a computer or other electronic device is also reproduction. Creating an audiobook, recording the author's text in audiobook format is one of the playback methods. Um, Right of reproduction. Any copying of a work without the author's permission is a violation of their right of reproduction. A copy for personal use is also considered a violation. Having permission from the author or other copyright holder to copy a literary work prevents legal problems. An author's property right is the right to distribute copies of their work. This means the author can control how and where their work will be sold, claimed, await rented, list, or otherwise distributed. Only the author has the right to decide how their work will be made public. Right of distribution. Distribution can be carried out in various ways. Sale. This is the most common method of distributing literary works. Authors can sell copies of their work directly or through bookstores, online retailers, etc. Donation. The author may give copies of his work to anyone at his own discretion. Rental, the author may private copies of his work for rent, for example, through libraries. Other methods of alienation, this could include, for example, barter when copies of his work as exchange for other goods or services. Right of public display, right of public display. This is another property right of another, which is closely related to the right of distribution, but it has its own characteristics. This is the author's right to control any public presentation of their work. When it is accessible to a wide audience, this can occur either directly or through technical means. Right of public display. Public display of literary work, public reading of a work at a literary evening festival, library, or any other public place, on-screen demonstration, displaying the text of a work on a screen during a lecture, presentation, or other public event, exhibition of copies of the work. For example, an exhibition of yours, editions of a book in Amazon library used in as performance when excerpts from a literary work are used in a performance.
You're doing great.
Narration of separated for literary works. During the author's life, the author holds all inclusive rights to their work. They may use the work at their own discretion, permit or prohibit its use by us, and receive compensation for its use. 50 years after the author's death, during this period, copyright is transferred to the authors as they can use the work managed there. Rights to it and receive compensation for its use after the 50-year period work and the public domain. This means anyone can freely use a work without permission or compensation. Separated protection of literary works. Separated registration. Benefit of registration, official confirmation of virtual a copyright registration certificate is an official document confirming your authorship of a work, simplification of its copyright protection process in the event of an virtual dispute. Having a certificate will significantly simplify the process of proving your rights in court, deterrent to potential infringement. Information about registered copyright can serve as the deterrent to those intending to illegally use your work. Proof of date of creation. Registration establishes as date of creation of a work which can be important in the event of an virtual dispute. Copyrighted protection of literary works actions in case of copyrighted infringement gathering evidence. It is important to document the violation, identifying the violator. This can be as an individual or legal entity, pre-title settlement, presenting demands and proposing solutions, filing a lawsuit to protect your copyright, filing a lawsuit with all enforcement evidence of a criminal offense. Conclusions. As a result of the analysis, characteristic features of literary works were identified, which can become the basis for The practical division of works write up, clarification of the legal status of their authors, and as a result, as a development of more effective methods of cooperated protections. Thank you very much.
Thank you very much, Professor Saltanat from Kyrgyzstan National University. This was a very informative review of copyright protection in Kyrgyzstan. And, if I understand correctly, one of the main issue remains the bundling together of all these literary works rather than trying to understand the difference between some scientific publication or computer science, computer works and so on that are all literary work, all treated in the same way, yet each of those has specific challenges. So that's the jurisprudence probably in Kyrgyzstan is still developing. And you have clearly a system that is compatible and in line with the Berne Convention and the TRIPS agreement and all the other current international legislation. Probably you will soon start developing more cases, and it will be really interesting to see how this copyright infrastructure as it is will then be also implemented in the digital environment, with artificial intelligence and so on. So thank you again. Thank you. Now our next speaker, it's our colleague from Algeria, Professor, you can start going. Professor Najibia Boukemigia. She's a professor at the University of Algiers in Algeria, in Algiers, the Algiers one. Uh, and her publication, her research focuses on a different topic within IP. This time is patent, and we are going to discuss evergreening, so the problem of trying to renew the protection of patent, restarting the clock, particularly with respect to pharmaceutical products. This is a fairly hotly debated topic in many countries. So thank you very much, Nabija, for your presentation.
Thank you so much, Professor Kabuli, for the introduction. Thank you for the university and for the faculty of about the opportunity. The topic is about evergreening in pharmaceutical patents. First, we have to say that medicines are not just products, they are power. The World Health Organization has stated that almost 2 billion people do not have regular access to essential medicine. In this context, a patent is not just legal right, it can become a barrier between a patient and treatment. During global health crisis like IHIVs or COVID-19, this debate becomes even more visible. Who controls patents, who produces medicines, who gets access first? These are geopolitical questions. For evergreening patent, we can say that evergreening means keeping the monopoly alive by attending new legal methods around a node medicine. And the difference between evergreening and generic medicines is concerned that generic medicine is a cheaper version of an original medicine. It contains the same active ingredient, and it can enter the market after the main patent protection ends. So the conflict between evergreening and generic medicines is very clear about the market. Evergreen delays competition, generic medicines create competition and competitors matter. In the US, generic and biosimilars represented about 90% of prescriptions treat, but only 17.5% of prescriptions. At the same area, that means that most patients use generics, but most money be still spent on expensive branded drugs. Also, the FDA estimated that generic drugs approved in 2020 generated about $19.5 billion in saving drugs the following 12 months. So generics are not just copies, they are public health tools. For the legal analysis, legally evergreen can have a positive side when the change is real. For example, if company develops a version of medicine that reduces side effects, improves absorptions, or makes treatment easier for patients, this can be a legitimate improvement. But a legal problem begins when the changes is slow. For the TRIPS agreement, this agreement sets international rules for all IP laws and also patents. According to the Article 27, patents must be new, evolve, and inventive step and be useful. However, the Doha Declaration clarified that countries also have the right to protect public health and ensure access to medicine. So the legal of the study and the goal is to find a balance between innovation and access to medicines. From EU position, in the EU, evergreen is not directly illegal. There is no law that clearly says you can't extend your patent. But here is the interesting part. The EU watches very carefully how companies use a patent because in the EU, the problem is not the patent itself, but the problem is how it is used. It means the competition, whether of the using of the patent, evergreen patent. Also, the EU has specific pharmaceutical tools. One of them is the Supplementary Protection Certificate, or SPS. SPS means Supplementary Protection Certificate, regulated by the regulation 469 2009. The SPC can extend protection for a medicine after a basic patent expires, but it cannot exceed 5 years. The idea is to compensate companies for the time lost during the authorization before medicine reaches the market. The case is about the European case is about the AstraZeneca case. It's one of the most important examples in the EU. AstraZeneca had a very successful drug called Losec. When generic medicine were about to enter the market, the company used two strategies. The first one is gave misleading information to obtain extra protection through SPS, extending its monopoly. The second one is to remove its drugs authorization in some countries, making it harder for generics to get approval. In 2005, the European Commission fined the company 60 million. Then the case continued until 2012, when the Court of Justice confirmed that AstraZeneca had abused its dominant position. From the next, from the Turkish legal position, Turkey doesn't have a rule clearly says evergreening is prohibited by, but at the same time, it doesn't allow unlimited protection either. So the Turkish system is based on balance. Patent protection in Turkey mainly governed by the industrial property law 6769 entered in force in 2017. Also, the Turkish law follows US standards to obtain a patent. An invention must be new, involve an inventive step, and industrial application. It's the same for all countries. Also, Turkey controls abuse through law 4054 on the protection of the competition. Similar to the EU law, dominant companies cannot block competitors unfairly, so some patents can be investigated. From the third position is about India's positions on pharmaceutical evergreening. India adopts one of the clearest and the strongest legal positions against pharmaceutical evergreening, and this position is mainly based on Section 3D of the Indian Patents Act 1970 as amended in 2005. India makes a clear distinction between improving drugs properties and improving its medical effect on patients. For example, changes such as better stability or storage conditions are not sufficiently to obtain a new patent because they does not necessarily make the treatment more effective. Then the law even goes further by listing example like salts, esters, polymorphs, and isomers, and considers them as the same substance unless they demonstrate significant improvement in how the drug actually works in the body. The famous case about Indians' position is between Novartis vs. Union of India in 2013. Novartis wanted patent for a new crystalline from the medicine of imatinib, sold as clinic cancer medicine. The Indian Supreme Court rejected the patent because Indian law requires proof of enhanced therapeutic efficacy, not just better physical properties. This case became symbolic because India basically said we protect real innovation, not legal tricks. For the conclusion, we conclude that pharmaceutical patent evergreening is not always evil. Sometimes secondary patent can represent a real medical improvement, easier use, fewer side effects, but when evergreening used mainly to block generic medicines, it becomes legally questionable, economically harmful, and geopolitically unfair. The best question is a balance. Also balance, protect real innovation, reject fake innovation, allow generics after a fair period, and use competition law against abuse strategies. In one sentence, a patent should award discovery, not protect a monopoly forever. And thank you so much.
So excellent. As you can see here, we are moving in a completely different area of intellectual property. looking at a comparative analysis of the you know the extension of patent life through trying to find protection for parts of a new invention that might not be as not no as known might be actually not as new as it seems or is purported to be. So, any question? We are running out of time, so it would be a good idea to just keep the questioning. We have maybe 5 minutes, but it would be nice to have maybe a couple of questions for our panel. Professor De Vera, please.
This very interesting topic, which is to have your sense as to whether this risk of evergreening way low or not because of AI, artificial intelligence, which might be used, as we know, to do drug discovery. And I was wondering whether this could have an impact potentially on the risk of evergreening because companies will likely already do today use AI tools to generate innovation. I was curious to have your sense if you have any idea. Of course, this is an open question to see whether you have thoughts about this topic.
There's no microphone. Speak loud. Just speak loud. Speak loud. Come on.
We will be fast, yes. Yes, the AI has its influence about only the topic, but I think that the problematic is deeper than AI. Actually, the problematic is between rich countries and poor countries. Rich countries say patent innovation, and poor countries suffer with, say, protect access to life-saving medicine. Both, I think, two arguments are important, but at the same way, we have an imbalance, but what? But a passion in a wealthy country and a passion in a poor country. A passion in a wealthy country may have insurance, I think it's easily for him, or state support, while patient in a poor country may simply not receive treatment, unfortunately. But actually, I think that it is more question, it is related more to the geopolitic subject than the AI subject, relating to although poor countries.
Okay.
Thank you.
Okay, may I actually, sorry, this is something that for me is very important. We need to be careful about generalizations. The big problem of pharmaceuticals, it's not patent, it's manufacturing capacity. In developing country and least developed country, most drugs are not patented, meaning that a third-party company could open up a shop and copy everything they want. In LDCs, medicines are not patented because this country have extensions. So I don't know if in Algeria there is a lot of pharmaceutical patents, for example. So many of these drugs could be copied tomorrow in Cambodia, in Burkina Faso, anywhere, because there is no patent. The problem is those countries don't have the manufacturing capacity. They don't have the skills. They don't have the people who know how to do it. So the technology transfer is the issue, first of all. Second, it's not about poor country and rich country, because I can tell you, people in the United States, many don't have insurance, and the cost of medicine is astronomical. While in some developing countries like India that are very strong, or Bangladesh that are very strong in pharmaceutical generics manufacturing, access to basic medicine is easier and simpler. Many countries have negotiated government rates while the US does not. So I think, careful about generalization and thinking that the good, the bad, the poor, the rich, it's people, it's company, it's transnationality, it's multinational. This is a very complex debate where simplification can be very dangerous because we need innovation in medication. There is a lot of cost, and at the same time, there is a question of access. So to modulate responses and to understand in details the problem, it's crucial. And manufacturing capacity and trying to bring up the ability of developing and least developed country to have skills and invest in science, invest in people so they know how to do the actual creation of this medicine is the number one issue. So that the law often is very much below the real problems because the problem is people don't know how to make it. India has a major, this is why they have this law, because it's favor national industry, copying foreign company to favor national industry. Country like Switzerland favor national industry through stronger patent protection. So honestly, it depends. But obviously, bottom line is we need to have more access to more medicine to as many people as possible, as cheap as possible. So this is and how we modulate that remains really important. So sometime I think in your research, I strongly encourage you to trying to modulate a bit of that because that makes everything more credible and more fact based. I think.
I think, sorry, I think it depends also of the topic that we have to define. If we have to define the rights of the health of developing countries, it's not the same as pharmaceutical company that may spend years and huge amounts of money. Then we have contradiction, yes, balance economic interest and health interest, and I hope us also have interest to developing countries.
I would say I favor right of health for every person in the world.
We have to balance. Yeah.
But again, the American people, many don't have insurance and they have less access to medicine than people in some developing countries.
Yeah.
So again, it depends.
Economic interest, yes.
Exactly. And so I think it's people versus corporate interest. And the people have to really be united in that because it's when you move it to geopolitics at the end of the day, you keep entrapping the debate. Um, and I think again, the price of innovation often falls on people everywhere. And this is something that we need to understand in a way that needs to be rebalanced because at the end of the day, people health it's not less valuable in India than in Switzerland, than in Nigeria, than in the States. All people health is same valuable, I think. Country, no. I have a question for copywriting Kyrgyzstan. What do you think is the main challenge now? So you talk about challenges. If you can see, if you could point the one issue that you think has to be fixed first, or the one issue that is the most interesting, what would you say? And you can answer in Turkish and then you can translate.
Спасибо за вопрос. Действительно, на сегодняшний день по нашему законодательству, по законодательству Советской Республики и по законодательству Республики Турция, эта проблема существует. Именно проблема определения существует литературного произведения. Что следует на сегодняшний день относить к категории литературных произведений, по каким критериям следует составлять эти понятия, да, что относится к объектам авторского права. Но анализируя законодательство Кыргызстана и законодательство Турецкой Республики, мы пришли к выводу о том, что все-таки по нынешнему законодательству литературное произведение связывают исключительно с физическим лицом, с произведением его работы, да, тогда как именно по законодательству Турецкой Республики там уже связывают с производством, с произведением, с именно тем продуктом, который произведен этим автором. Есть еще проблемы того, что, значит, например, у нас, мы говорим, да, охрана авторских прав. Срок на сегодняшний день по нашему законодательству это 50 лет, тогда как по законодательству Турецкой Республики это 70 лет. И мы идем к тому, чтобы все-таки приблизить вот этот срок до, значит, и как бы иметь схожесть с законодательством Турецкой Республики и приблизить этот срок защиты авторских прав до 70 лет, как по международным документам, согласно международным нормам.
Спасибо. Could you translate, please?
Yes, of course. So she was talking about what we should include in the literacy. Yeah, so that was the first problem that she was talking about. And the last one, she's thinking about that, for example, the author's rights should be saved in her country for 50 years. Yeah, and she mentioned in Turkey it's 70 years. So hopefully they want to prolong it as your example in Turkey.
Okay, so they will not, or they will.
They are going to, so she hopes they will.
They would.
Yeah.
They would not. They would,
They-
yes.
They will.
Will. This is interesting because, for example, Canada, New Zealand, they still have life plus 50 and they don't want to go life plus 70. Singapore had to do that because of the free trade agreement with the US. So you have a lot of pressure from from FTAs to push longer protection. Even in developed countries, there is a lot of pushback by particularly publishing houses because they don't want to pay royalties for the extra 20 years. So it's going to be interesting to see who is going to be the winner in the extra 20 years, for example. Yeah, like Canada, no, and so it's there is pros and cons in extra.
Организации развития вообще сети интернет, искусственный интеллект, вот это вот проблема угроза того, что все-таки возникнет необходимость защиты прав, авторских прав, да, любого индивида физического, это стоит. Поэтому есть все-таки необходимость увеличить срок, 10-летний срок до 70-летнего и приблизить международным стандартам. Это поможет все-таки, да, значит, предпринять все меры для того, чтобы защитить права человека в сфере авторских прав. Вот. Еще одна проблема, которую мы вчера тоже поднимали, это проблема, значит, специализированности судов именно в сфере разрешения споров в сфере интеллектуальной собственности. Это тоже очень хорошая практика. Должны брать из, допустим, законодательства Турецкой Республики, из практики других стран, поэтому мы, я надеюсь, что к этому наше законодательство тоже будет подтолкнуто, значит, предпринять все меры для того, чтобы как бы эффективно регулировать эту деятельность путем совершенствования действующего законодательства.
Okay, so she's thinking that it executes the problem as artificial intelligence is enhancing right now. So it may open the threat, yeah, the prolonging for 20 years. And another problem she mentioned that yesterday, moderators mentioned that there should be special court. So that's the problem she wants to talk about.
Okay. And what about moral rights? I assume Kyrgyzstan has moral rights or not? We didn't talk about moral rights in copyright, right of integrity, right of, so you know the moral rights? Maybe if you just translate moral rights. Does Kyrgyzstan have moral rights?
Да. Плюс, значит, так как мы правовое государство, да, в Конституции так и сказано в статье 1, что мы правовое государство, соответственно, в приоритете у нас норма права. Ну и, конечно, также в Конституции нам предусмотрено, значит, соблюдение моральных норм. Например, это опять-таки уважение правей, уважение старших, да, значит, ну, там, младших. Это опять-таки те моральные нормы, которые заложены как основа в Конституции, но потом они в последующем уже в жизни, в обществе не соблюдаются. Да, мы все-таки мы пренебрегаем нормами морали.
Okay, спасибо. Very interesting. The Shiba.
She said yes. So by the constitution, the rights, so it's the moral rights. So she was talking about that we should respect other people and we should take care of our youngsters.
Okay. Excellent. I think we can close the panel and move to the certificate ceremony. I think it's fine. Or you hold on.
What?
No, nothing.
All right. We would like to thank to our distinguished speakers, and now we will now like to invite Professor Dr. Canan Küçükalı, Dean of the Faculty of Law at Islamabad Design
No,
University.
director.
I will talk about that. To the stage to present certificates.
Okay.
Participants, there's going to be a live break right now, and the season will be starting at 2 p.m. Thank you.